Yes, I guess we're not waiting on me, actually. Legitimacy advantage U.S. credibility collapse due to detention policy plan versus that Welsh love this force damage America's image monitors growing consensus America's like credibility is the world leader perceived legitimacy of U.S. critical serious non-conventional left this battle will be won through legitimacy rule of law over ideal policy and negatively pet legitimacy with most damage in detention court oversight is the way for detention policy it's only restore America's image monitors law 2009 Guantanamo was closed the National Security Court now and national security may be the next example of justice as we are fighting hybrid wars, hybrid courts can be adjudicated to adjudicate the keys of balance, national security court and keep rise, and obtaining the delicate balance, security the most practical ways to locate the NC on military bases, the basically far better suited to handle situations than the court's military oversight would be transferred to civilian control, having civilian oversee the court's regional success, and any way help will restore America's image broad use system needs to be adjudicated rather than trying to contain in NSC is best means for U.S. regain moral authority, moral affairs, only U.S. getting credibility to demonstrate dedicated to all public rule of law, the plans, external oversight, mechanism of detention is critical to hegemony, legitimacy is vital internally to global stability, and also has not had to run a model routine for executive legislative and institutional terrain, shift towards forcibility depends on the use of the depends on the ability of government effective governance, depends on predictability, the rule of law, and institutional policy are the equivalent of corporate accountability, state law, but also stability of international systems because the nation know they can rely on those interpretation, and this would be sort of global governance function detaining possibilities vastly aggressive and anarchic world one can make the executive requires maximum flexibility with today there's some strength the dangers that American rule break will set a pattern for the world, letting instability with the U.S. practices own rules of legitimacy. And American world legitimacy drives reinforcement ahead of money to support government depends on military acquiescence, the court's prepared role to play rather than public foreign policy, where to keep foreign stop power, force so legitimacy in the act have based on more rule of law, more legitimate, was foreign policy, actually the detention of America's image, our looking reputation, strength, legitimacy was hegemony by establishing equality, benchmark, reinforcing our constitutional values, works with legitimate American leadership, nuclear wars, saying she 11 distribution of power, it should be able to enable the world less peaceful, American many actors banned with U.S. hegemony, creating static that military power complex hegemony with wars may be hard to avoid history, test of power decline, results in military confrontation, as such, stability for market trade, financial mechanisms have appeared post-Senator world, return to regional trade, regional block trade conflicts, rivalry of world without American Germany's one where great power wars re-emerge, material power is irrelevant, lack of legitimacy makes hegemony ineffective. Mendelssohn, 2010 U.S. is overreach of the one terrorism and the second year president legitimacy make objective on the table of U.S. handling of power hegemony should be our understood and partisan by head of relates other states that through shared arms head of ruling the international media rising legitimacy head of money willing to pursue the collective interest to be international cooperation independently absent renewal of rule of law principles multilateral cooperation to solve warming diseases impossible I agree when you pull over the past with the institutional foundation of the one with the reestablishment of the global authorities global leader warning and security pandemics but in reliability civil goal system these to realize that the global order itself we put over the U.S. allowing itself need to share power and rely on others to ensure security what do above all else need to respect this global leader warming causes extinction for all potential catastrophic climate change is real there's an overwhelming scientific evidence showing positive correlation between CO2 with respect to global temperature changes the overwhelming majority of scientific in the group of the risk of catastrophic climate change the risk of catastrophic and climate change can be the extinction of human species, diseases cause extinction, quantum control disease all around under order condition natural, but aberrations occur from this pathogen spill over from people to animals, scientific history preceding symptoms move that are airports, evolves a well-adapted fair airport transition, this separates global places from global pandemic, the possibility global disaster, no climate has been upon the planet like we do, we're not breaking out, and judicial involvement is key to credibility of detention decision, waxman, non-judicial review, health, stability, enhanced credibility of detention decision, welfare reform, start with stronger control over the courts of the court is debated from this age, just defense for these, have shown possible legitimacy, perceived legitimacy, the elements may help reduce mistakes and restore credibility of detention, democracy advantage. Democratic liberalism is backed by the U.S. model of an unrestrained executive, cost of life, time and conservative democracy for a war to gathering, trying to democratic process and global extension of the level of there's all very against the last 9 years, number of countries leader in privatized zone, while known as more countries in many countries intended for eroding over the 80 new democracy that emerged 3 quarters and secured risk reversal, listening to leave from states to Turkey, Indonesia, Pakistan, Mexico, where the constitutional rule cannot be taken for granted, advised democracy become denominated enough for the right of executive strength and liberalism. Democratic transitions are hanging in the balance now, only empowering checks on the executive through the rule of law, can tip the scale, CGA to the sport. Some countries successful legitimacy for them, the democratic judicial rule, the other hand, they hang in the balance, are against time, and their attempts to ensure the rights of democracy, emerging democracy consistently to U.S. and fashion farmers establishing judicial review is a critical step in the stabilizing democracy countries that transition recognize integrated governance based on the rule of law with other rule of law option simply other choice to advantage America should advance the rule of law. The rule of law is essential. U.S. detention policy is key. It justifies democratic backsliding globally. CJA 2004, the hallmarks of tyranny's lack of strong judiciary rules go down the road justify the action based on the modeling of the U.S. and independence of judiciary is always under assault. The penetrating this also have one of the U.S. models justify their action that reference U.S. action detaining personal erosion, civil liberties, and this is good and blank check nation who are combating human rights. Every dictator in the world using U.S. with the U.S. has done about human rights and definite attention to help create free license for tyranny. Now the U.S. obviously sets an important example on the issue of the U.S. model. One of the judiciary check the power others justify the use reference to the U.S. detention court is critical to the preservation of U.S. democratic ideals. So Islamic 2009 and a single report opportunity policy responding effectively to international policy making to merge with the factory ways to power education in the time of the U.S. bringing a military human prosecution. There's no better way to prosecute terrorists in a manner consistent ideals they seek to destroy. That results future Gitmo-like problems in his model to global Kimmery does not. The nation needs one so the National Security Court that offers the way of U.S. the way of game of homes in the future. They approach not only restore respect for America's system of justice and legitimate saying one prisoners serve as a temple for the nation and the court where everybody's fair how we yield attention to critical winning the war of the UN. Now the U.S. requires a judicial system to go on where global democratic transitions are enabled. The only way for the U.S. to bolster democracies is with constitutionalism solves wars. Zachariah 970 democracy not preserve liberty, law, democracy, small constellation. The only alternative there are no alternatives. Democracy, the problems with the government will be problems with the democracy, greater danger, liberal democracy, possibility just liberal democracy, self-casting, shadow democratic governments everywhere. Democracy has been followed by setback the last such privacy part of the democracy. The U.S. was the most peaceful world. The U.S. ladies have served for you. democracy, encourage constitutional liberal democracy, liberalism is dangerous for abuse, I think division, war, democratic backsliding, cause great power, gap, declining major power wars, deep in one wonder, spirits on couple like maybe start probably major power wars, main load is irresistible to the government is that starting with the return of the capital, some democratic power, great power, trying to represent the greatest change to the global power, Russia, return capitals may be more viable to be able to democratic Germany, be short lived universal democratic peace, may be far off, China versus their hostile antagonism, relations, or ideological rivalry, calling 10 by armed races, independently the plan prevents eroding checks on executive power that create global dissident crackdowns, wax and 9. Innocent individual will get imprisoned and expansion detention risk of running checks on state power detention and kind of low weapons even occurs to that way the U.S. use detention also may necessary foreign regimes will not be the U.S. needs to be cautious about justifying principles that might be used by less democratic regimes. The pretext for crackdown the dissidents they label threats. Chinese crackdowns on Uyghurs makes them stronger, cause 8 more days of David doesn't take more short we remove joining with internal international movements and bringing influx of extremists and downers towns of government movement to radicalize the Tibetans the Beijing successfully managing the separatist movements and the Chinese reaction however large determined the process of separatist movements with the strike campaigns the regime to discriminate separatist movements will hold governments to worry about the training camps and also fear fragmented China political instability in China impact all of Asia. Asia war goes nuclear, no defense. Mohan 2030 war break down no war between great powers only try on with dual weapons and economic defense is on the for peace. We have seen those between the PRC and US and dual weapons and geopolitical competition now. This seems to be one of the great powers likely to force the happen when the great power becomes the roles in the conflict state often high value should barely be uncreating institutional fiber resolve the security challenges bounce power rows are inherently stable and breakdowns lead them to systemic breakdowns are frequently lead to systemic wars independently. The plan reinvigorates due process and detention. Guara to this 12 traveling on rights always information the rule of law is that some sort of little today's must be wrapped for revenue different detention commission no woman care of the national security I have advocated for the question is whether due process to protect your principle due process act and the demand U.S. security accountability could be detention without troubles violation of due process and that's the proper judicial process of the time is coming to words and spirit of law and the like case here tonight do not introduce case into accountability and harmony instances again is essential to defect the rule of law that spills over to immigration detention policy five self within public structure political institution acts will lose members contribute to the formulation detention system this and this is significant inflation due process for suspect more important than for the vital state to adopt detention system to protect due process this can be journalists. Beyond security to define the detention, the immigration and quarantine policy, meaningful limited creating systems, U.S. immigration detainee rights or Kyoshu for U.S.-Mexico relations, Lovato, 2009 source by the Guan China Lake Farms of the country, immigration detention system, tarnishing the Summer Rwanda aspect of Mexican government is to statement of the protest and immigration detention story, state of Mexican culture, how because there was abuse of fellow citizens the same way the Guantanamo issue was human rights, practicing detention, immigration detention feels made between individuals and doing so something does not change the way for the world of refugees on a simple when it comes to immigration, U.S. to Mexico relations are key to solving the drug war, the impact is regional stability, shared love and the opportunity for U.S. I think U.S. Mexico cooperation here, the comes to the best state for the same world, and your turn point together, parties Mexico drug war, we drag on downward greater and more geographically discord violence and direct more political movements by organized crime rising to political leading to affecting neighbor countries challenge for double really greater trust and cooperation requires the same conflict U.S. can help shift the balance of the balance of organization and crime and the farther the balance with this product service here from U.S. U.S. responsibilities Latin America instability causes extinction man's work in the state failure is the most dangerous security challenge facing global community field in the states that is pretty good for instability terrorism of these against rights violation poverty starvation disease and the proliferation of conventional weapons and WMDs these actions will regional center conflict order dysfunctional states persist and more likely to problems of danger global peace and security and prosperity the United States federal government should create a national security court with exclusive jurisdiction over the United States' indefinite detention policy in the area prescribed by the 2001 authorization for the use of military force solvency. The creation of an NSC is crucial to restore the legitimacy and the rule of law. Detention also of the legitimacy is critical missing element of the current U.S. detention regime influence the other military coercion and inefficient legitimacy rather than terms of one cause individual way obey comments. Publicly perceive the law to be legitimate terrorism and how we want to decrease military force benefit. Dark maximize the legitimacy into one of the World War II. The social rest of our quote supported by the four pillars. The U.S. legitimate self the world country grab. Following on the limit nation to support completely evaporate governments overreaction across the globe and individuals states for sensitive action. Current U.S. detention policy ready to the four pillars which establish U.S. global legitimacy Obama versus temporary articulation detention policy countries policy argument establishment of domestic care court the court's procedural justice is key to solve Watch 11. Procedural justice may particularly more to the content of detention judgment effort is important to the individual experience and integrated. Unfavorable to the minority individuals who care about the process also critical to procedural justice, the perspective of moral honesty individual, the common sense of preserved fairness, and efforts to high procedural justice backfires. NSC is the key solution. NSC, Campbell does not have this accomplish military commission article yours. Detention not filled in the regimes of NSC provides the best for make an alternative case as well as a huge capture the nation need to go further and great importance in the best suited for their unique fight rather than offering option. The NSC provides one form to attain down rise to process and security with their two existing paradigms of sharing square pegging that whole NSC must be presumptively judicatory this vital to ensure the rule of law and maintain international support. And the plan restores legitimacy, outweighs benefits from indefinite detention, which doesn't need the benefit of detention and incapacitation to detention is outweighed the individual policy cause use legitimacy unemployed detention provides a better kill value of intelligence diminished over time. The reality provides justification for indefinite detention for the intel current regime damage legitimacy. This applies double legal double standard for purposes are consistent legal norms that undermine U.S. strategic legitimacy.
You good?
Yeah.
Alright. What is a national security court in the context of the plan?
It would be part Article 3, part Article 1 court that is seen under civilian oversight. Our evidence says it would be a mix of judges from the Department of Justice. Well, not judges from the Department of Justice. The civilians overseeing it would be from the DOJ. But it would be a mix of judges and military experts.
All right. What does it change about the current process of which these people are being tried?
It bans Obama's ability to try them in military commissions.
Right. Okay. So Obama can't try them under military commissions. What's the difference between the current military commissions and the plan?
The military commissions don't give them habeas hearings.
Don't give them habeas hearings. Or what are like the procedural differences?
Due process, determining innocence or guilt, the independence of the court itself is necessary to its legitimacy.
Okay. Who is tried in this national security court?
Detainees at Guantanamo.
Detainees at Guantanamo.
And
Okay.
future.
And future. Yeah, obviously. Okay. Who are the judges that are involved in the?
Yeah, it's Article 3 judges in military.
Okay. How do they determine who the judges are? Like, what's the process?
It would find Article 3 judges who have areas of expertise in national security as well as military experts.
And
All right.
security clearance.
And security claims. All right. And if
Security clearance.
So what happens in the world of the plan that is? I don't understand why is current not legitimate versus the plan.
Because military commissions are not open; they're not actually resulting.
All right. So the National Security Court, does it have like a jury of like peers? No. All right. What are the standards? What are the standards for evidence?
The system does not have Article 3 judges.
No. What's the standard
is
for
a clear
evidence in the
distinction.
National Security Court?
What?
What's the standard of evidence?
It's no longer just hearsay. Which
It's
is
no
what
longer just
military
hearsay.
commissions
Okay.
use. There needs to be some-
And then let's talk about the hedge advantage. Let's talk about the hedge advantage. You read some cards about why hedge solves deterrence, like the J and G evidence says, like hedge U.S. primacy causes or checks great power conflicts, which seems to, if that argument is true, why does like Latin America and Mexico independently escalate?
Wait, what do you mean?
All right. So you read J and G card says hedge is a
The
deterrent factor.
impact of Latin America is failed states.
All right. Oh, who intervenes in the failed states then?
Our argument is that there will be WMD proliferation, terrorism, etc.
All right. So does hedge in a world of hegemony? Do those things escalate?
Arjun, do that.
I mean,
Honesty doesn't really take a
All
stand.
right. So if it's true that it doesn't solve escalation,
I didn't say that.
What? Well, your J and G evidence says that it would solve all great power conflict and escalation. So which one's true? Are the things that break
well,
down
there can
hedge
still
such as
be
terrorists?
There can still be low-level conflict and terrorist escalation in the context of WMD being used without great power.
If there's
Okay.
state, if
And
there's
then
state,
the plan-
if there's state failure, if
All right.
there's state
And what authority is AUMF under?
what do you mean?
What? So AUMF.
The AUMF is the authority.
Yeah, but what? Like, is it war power authority?
I mean, I would assume so.
Yeah,
Otherwise,
it is
it's
a
like
Okay.
full
Okay.
powers authority
Thank
that you can-
Okay, I just said that 5 advantage, 1 advantage 2. You said 5?
yeah. Great.
You all have it up? You all good?
Yep.
Good.
Violation of the act is vague on the character of NSC voting issue, limiting vagueness in the context of NSC's higher question bladder. Not proposed legislation are dangerously incomplete proposals from the national security courts. Do exceed the low British Academy cannot have intel, and unless to resolve critical questions as it's about the government's authority, and starts its constitutional rights, in fact, complicate sovereignty, and answers account for the downloads to HR shift to the ideal court just because we introduced laws preventing next off interpretation, restriction, price prohibition of entire topic area, less restriction is prohibition corpus, jurisdiction under 31 restrictions to prevent from action to restrain without bounds authority, is power delegated to Nature Kelly. 3 authorities defined including power delegated by principle to nature in the area means all the activities used. United Nations 13 use of terms activities in the area means all activities in the area violation of the act doesn't prohibit voting issue. Limits absolute prohibition of an area every single condition or regulation taxes as a functional restriction on some single process of war powers authority dozens of tiny mechanisms small subsets of areas create the infinite number of aspects the core literature doesn't check bidirectionality after prohibition the act can create meaningless conditions that expand presidential power competency commission consultation proves and center no data commission on war power recommended consultation to perverse the diversity that our companies will allow the president to much prior to security met a report the president's name research required to classes which proposed the vastly expanded presidential war factors and war powers options begun for practice of the House and Senate will be allowed to trust committee members next off national security course causes racial targeted segregation. The primary national security course permeates and devastates any conservative rule of law setting 10 the specialized course not be used the fact that the U.S. students use specialized tribes houses which are special all who have to be not citizens who are Muslim authorities more than flag that council towards the abolishing specialized segregated systems organized not gain traction given to the federal founded the breadth of the American published sexual dispute for the same type of protection factors differential distributed those defendants legislative trial specialized course attributed to shift away from that years to the rule of public regulated travelers towards about the national security concerns are given the right to regardless of the moral cost of whether utilitarian proven as national security against the impact of violence against the periphery discursive constructions key about the national security and the role in the notion always supposed to pursue new levels of national security hearings national security reasons to come to by judicial act discussion to focus especially on serious security options based security options shades jurisdiction closes to the foreign policy in ways that other often inhibit rather than demote actual security clarification of terms of securities in order as conceptual boundaries and part of the term security and which is national security place to national security is relative nothing about the constitution which holds the script to the 20th century national security it will nothing to never competing approaches matters next problem lies security more concept by combining divergent subjects completely competing notions which you have with democratic deals with problems with the government national security this is matter of the challenge of those assumptions is required to this is popular matters of safety next off counterpart text the United States federal government should provide traditional Article 3 courts exclusive jurisdiction over the United States indefinite detention policies in the area prescribed by the 2001 authorization for use of military force. This is forced to ensure that sufficient resources are available for training, preparation, and trial. Criminal trials solve better in NSC's devastating rule of law and due process speech. Eight calls call for NSC these proposals under the development is the neglect principles of constitutional law. Estimated to practically traditional process proven to reflect the idea there's a class of for whom neither civilian or military justice is presupposed guilty. Government competence of legitimate qualities and existing law legal procedures that resort to departures from constitutions and constitutional tradition advocates in a city limited art course are unequipped. This is not business guarantee to make the basis to suggesting things to our body. After those contrary to the reason for demonstrated this in course there's a car company reported working 100 terrorism cases over 15 years course were able to try this key to prove outside national security or the defendants try to trial course artists granted by the established constitutional levels for specialized course are recommending certain need for these to relax strategic efforts goals there are just right the constitution not to serve full constitutional practice to justify and the martial limitations of the right trials for terrorists adjunct presumption of innocence the also to share the best process in NSC are dangerous there is creating something on the equal privilege justice I said on the rights presumption the innocence risk religion to defend rights construct registrational articles 3 course more funding overcomes logistical barriers and off 90% trials conducted article 3 course of a day next time number practice challenge but there is significant practical challenge the viability of article 3 course the like terrorism are extreme lengths of high capacity to and distribution allocation resources challenges post terrorism handling article 3 course next off Obama's pushing Congress to resolve the dead zone political capital speeding success phase 9 political things with Syria on hold by the passage of treasury the national agenda his artist the national strength Daniel capital starter the same country to refocus on failures and dead still drag still fragile to frozen fragile economic policies since his limited when the progress of the matters the second short to with land status creep up the White House space by Republican door the nations that's the only President says he wants to negotiate European votes system to really the plans of population is army to war this war and terror to call off 60 defense houses voting to allow the Texas supporting the nation needs build the rest of effective terrorists including Americans there arguing on 206 billion cops of the economy things that today isn't the victim like well half of the country isn't to won't be nice national crisis that can't stand beyond the roads to benchmark currency then the goal for instance is well in addition to air and division of financially economic growth of the largest financial disaster industry small number of houses becomes we are willing to let it happen if the debt ceiling is for chasing rates also disasters for Russia to sell their bonds the U.S. economy would cost farmers then I think we've seen the past year the entire economy would converse to nuclear warfare workers just shown field there consequences of collapse of the financial architecture Iran Mercury is extended to their belt to develop to advance Pakistan, Afghanistan, militants trying to build give consequences to their persuasion that he's creating down to a whole room stays many become nuclear leaders and divert attention from international to external conflicts now the legitimacy advantage the plan collapse the legitimacy credibility and rule of law official not to Obama's considered NCD official prosecution terrorism threats and special what is often beginning to take status strategy and also for driving advantage to the court black confidence classified information as well to experience their intuition such an instance that's the necessity what constitutes constitutional abomination was only reported to court the Campbell continued recourse to the report the institution justice the judge of the NSC class a category of people purposely not entitled to make the constitution given right to culture to the presumption benefits with opportunities to particularly defend themselves with charges currents of public USD routinely objecting about the procedures and the country's courts being broadened subject to provision to prove the rule of public interest to begin to dissociate notions of human rights and the but institution I think the force respect to the detention and steal or other jurisdiction to the federal court autonomous to move using the state is that rather the world entirely to see another they're often trouble business emergencies have reduced emergency systems to the subject of the judicial jurisdiction have administrations in the seas are perceived as an extension of constitutional trials schools and special work for terrorism conducted by counter to the strategies the average just more engaged stating important advantage to tell God create and other substitutes and we've seen as we're changing business for the discredited by tunnel military missions failure such course to enforce the and match all the collision with the road very credible beyond the realm counters and national security for collapses legitimacy fuels anti-Americans and French cooperation Colton that's terrorist court not necessary by the question for this guy to go to most of the difficulty trying to create new and not justice system a new court definitely would argument the litigation to think procedures to safeguard evidentiary standards of correct and bad work and justice new court would undermine justice and perpetuate the damage of America's reputation and trying outside of the normal criminal system collapses credibility Colton Special government whatever from the arresting young lives without compromise and security justified difference due process are procedural safety security security definition cities and to that work of American justice the same sets of the for the numbers that's to being arts as a whole rising American deficit to forge and the national coalition for the damage of America's reputation now the advantage of democratic peace theories false interesting due to democracy science and has to people to decrease the likelihood of the national west democratic peace and that for instance that's why to actually which are more than likely to have to see what we can press to work and from them they were honestly little bit more marked at peace. Now, Asian wars unlikely to her and that's related to the Asian Pacific doing both relatively and security strategies stability crucibles conjugation specific to the areas of comms with certain stable terrorism that stand North Korea the movement is conclusion China's Taiwan their renewable development organizations that's dedicated to enhance increase accessibility of the active housing war in Asia's unlicensed escalation in the Latin America is empirically denied cartel 2K Latin America was decided for them so wars with Latin America is extremely destabilizing complicity regions to be structured for the parts of the world which conflicts continue to rage in more than just 2000 more evidence of 2009 crackdown should have triggered their internal link Makitan 625 persons for Ray Markey for the interviews with the anniversary of the ethnic cleanse of the dearly trying to be played into the Arabian between July 2009 to Friday's evidence Friday's times followed the bloody clash when starting the time you can move the 45 people died was the least of the bloody incidents of riots in 2009.
Okay, well, thank you.
Those 22 seconds. All right. What's the net benefit to the counterplan?
Just the internal net benefit and the critique.
Did you read an alternative to the critique?
No, it's the counterplan.
And what is discursive? Well, how does discursive construction matter if you don't reject our discursive construction?
Because the counterplan solves that by providing a legitimate form of the habeas protection. So instead of treating them like terrorists and giving them a separate legal system, we would entitle them to the same legal privileges that citizens of the United States have.
Okay, so your Fisher evidence says that judges in Article 3 courts have done a superb job of managing the courtroom and not compromising our concerns about security and our concerns about classified information. If judges in Article 3 courts don't disclose classified information, how does the counterplan not link to your net benefits? Because that means there's things like restricting attorney-client privilege for the terrorists. That means there's things like not giving the defense attorney full information. I don't understand why this doesn't link to all of your net benefits.
No, that's not true. Just because this evidence does a good job, or just because this evidence says that those courts do a good job of not releasing that information, does not mean that there's not full disclosure within that court.
What part of your evidence says that?
I think you're cherry picking a line and construing it out to be something
Well,
else.
then show me a line that uncherry picks it for me.
Well, I don't think there's a specific line.
Well, that's what I think. I don't think you have a net benefit.
Right.
They
I think
either
you are
classify
just
the info, which means
right. The info is classified within the court. That means that it is not
the
leaked to the broader public or
attorney can
internal
go
agencies.
out. Like, the entire point is that the attorney can go out and then give information to. Yeah. Okay. Does the counterplan have a jury?
Yes, the counterplan is normal federal criminal courts.
Do those people have security clearance?
But
Can they go out
it's
and
the
talk to
normal
people?
criminal
Okay,
jury.
so how do you protect?
Okay, so there's no security clearance on the normal jury procedure.
Well, it's not like
So why doesn't
it's not like the Kansas District Court is the one doing it, right? It'd be within like the federal court.
What?
Still.
Oh, so? Like, I don't
Right,
understand why
those
that doesn't
people
result
aren't
in
like
release.
arbitrarily picked, and it's not like my mom is about to go be the juror for that, right? There's clearly like security screening.
That doesn't. That has no relevance to the
fact.
fact that the disclosure of information in a public court would probably dry up info necessary for counterterrorism. I just don't understand what your answer to that.
Right. So clearly, even in cases that are like high profile, they have to sign like pieces of paper that they're not going to leak that information.
You
They
have
can get
zero
prosecuted.
evidence to support
That's
this
true.
other than the line
That-
I
no,
cherry
that's-
picked, which
for
supports my
example,
argument.
like during the most recent trial for or public trials all the time is like they are sequestered during the trial. Nothing will happen. They get prosecuted. They
And then the trial's over and they can leave. Okay, in
Well,
the
no,
area
'cause,
means
like-
all activities from the UN. For the purposes of this convention, area means seabed. Why is this a predictable interpretation from the AF?
Defines in the areas as a term of art.
For this convention, why is that predictable?
Sure. I mean,
I agree. The plan prohibits Obama's ability to use military commissions. Why is that a prohibition?
because the possibility of indefinite detention still exists.
How?
We'll read evidence on that in the block because the court can rule that the person should still be detained indefinitely.
The court can find them guilty, which means they are then in jail.
No. They can sentence them to an indefinite period of detention.
So you mean find them guilty and put them in jail?
Right, but the distinction is that it's not a limited sentence, which means it's still indefinite detention.
There's such thing as life in prison.
Right, but that was not what the ruling is. So even in those situations, they say like 1 life term. Just think.
What is the impact to the cat? Did you read a card that says like racism comes first or anything?
No, it's just that
So why should we care? Like, what is the impact?
it's ethics.
Ethical.
Yeah.
Does ethics come before your other arguments? Like, why? Like, in regard to your other positions, how would you defend that?
If we go for the K, it comes first.
No, ethics. How does that relate to your other impacts, the 1AC and 1NC?
If we go for the K, ethics.
If
comes
we
first.
win that something in the
We'll
1
make
and C
arguments
was
about those
unethical,
distinctions.
how can you win?
What?
If we win that something in the 1 and C was unethical, how
It
can you win?
becomes a tiebreaker because we're both unethical, meaning equal to like equal to racism.
So ethics don't. Unless the debate's a perfect tie. giant bump there now.
I would recommend not doing that in the future.
Didn't get you any food, so you just have a little.
Yeah.
Auto cannibalism.
I got some extra.
You know.
I got some extra jaw skin. Is it in the thing folder?
Yeah, absolutely. It should be so big. Yes. Everyone ready for an order?
Yeah.
Legitimacy, democracy, vagueness, T, the counterplan, the national security bad race argument, and then
What was the button?
well,
Okay. Oh, sorry. I just got this email, so I need to download it. Okay, I'm good whenever everyone else is.
good.
The plan doesn't collapse legitimacy or rule of law. Another evidence assumes Article 3 judges exist, and the evidence standards are changed from the status quo plus exclusive jurisdiction, and the plan text will be a frame issue in which we are Congress set firm guidelines in the statutes that solve all of their circumvention and judicial creativity arguments in their evidence. It will not just look like Gitmo. The new process allows for due process, civilian judging, etc., which is a clear distinction from what the military commission process is now. It won't be bogged down. This can only possibly link to the cattle plan, not the plan, because our civilian court system cannot handle the overload which will be explained on the counter plan, but the plan's funding should be equally able to solve if the counter plan can. But even if not, the National Security Court would be more tailored towards this situation, which means it's better and more effective that Trishikov outside the system does not collapse legitimacy. Their evidence literally just cites humanrightsfirst.com, which means you should refer all of our professors who've done in-depth studies on this question and say that outside the court system would be effective, especially when it has civilian oversight like the plan does. Our model is best for legitimacy. They don't assume our mechanism of the DTC. Wells 11, the war on terrorism ideology shows that can only be one to legitimize the rule of law, undermining extremism, when governments don't overreact to Christ success under legitimacy rather than encouraging property. They defines the government policy and DT with the C model enhances perception of legitimacy and private procedurally fair process by properly balancing fairness, effectiveness, and efficiency. The model provides a workable solution that is better suited to the unique challenges and the vague standards employed by the current U.S. detention regime. Democracy advantage, democracy, peace, democratic peace theory is correct. Prefer gas, post-states, their evidence by 9 years. Post-states, their evidence and insights. All experts and empirics on this issue. Asian war will happen. Their defense is too old. Ours is from 2013. It says that there's no checks because of high tensions and lots of nuclear weapons making it highly likely. They've also conceded the internal language makes the magnitude of the impact more likely. They've also conceded all the other impacts on the other pages means they can literally not go for the stats, so they have to go for the counterpoint. We'll do more explanation of wanting to try to bring impact defense, topicality, vagueness. We meet. The app is not vague. Solvency advocates are super specific. Brishikov, as well as Walsh and the 1AC, are highly specific to what the NSC process would be. The second is cross-ex checks. We were highly specific on what the process would be. And the cross-ex as well would solve all of the offense counter-interpretation. The plan text should only have to specify enough to meet the resolutional burden, which is what we have done in this debate. And the fourth is it doesn't hurt sovereignty, which is their only impact argument. All of our cards say that the U.S. should create a national security court in exactly the context of the plan text is reasonability, good is good enough. If this type of interpretation causes a race to the bottom to arbitrarily point out little flaws in the plan to try to make the negative a little easier, they already have it well enough. Keep. We prohibit the executive from detaining indefinitely absent using a national security court, i.e. he can't use military commissions. Restrictions mean a limit or quantification and includes conditions of the action CAA in when the terms not specified to be assumed national law. Restrictions, limitation, or qualification limited, and restrictions are commonly accept the definition of driving for people limited against general not anomaly section for to solve that, but if for driving vehicles are these limitations cost restricting for each unable to drive in circumstances otherwise available. Statutory restriction means limits imposed by legislation. Black's law 13 limits placed on activities rights ruling legislation. Area means a field of study. Their definition is only about law. The dictionary.com. No date that a field of study or branch of a field in means within a set of limits. Dictionary.com. No date or use to indicate inclusion with the space limits. Preferred A's that found only process space have to be the executive template. They only allow 8 band apps, which lose depicts in every debate. B point is topic education. It's the authority topic, not the war on terror topic. Only reading a discussion of decision-making procedures more important. It's not bi-directional. We don't increase authority because oversight. We ban a certain thing that the president can do, which is not just oversight. Now the counterpoint. Conditionality, the voting issue, choice, expect clear, which keep the art of class and education, debate, depth, debate, field value. One, advocacy causes late developing page, direct team set of present, dispositionality, solves all their offense, permutation, do both, double solve things, accountable, and dex legitimacy, because it opens up the process to policy and the U.S. The use of military commissions has been disastrous, although now some advocate using the Article 3 system, such a policy would be more problematic, or probability successfully and humanely detained will be an issue upon which history will judge America. The best approach is to reject the virgin paradigm, to a more flexible third way, a hybrid system will be required to remain on the right side of history, restore a reputation abroad, and continue to make progress in the war, defeating terrorists. Does not mean victory in combat, but victory in rule of law. The road to that's the corner of the shooters toward false cardinals. The approach hybrid hybrid model will this cycle change the willingness to test parallel. And he should not take place in miracles legal approach, perception of matter 21st century no longer. This is more harm to America's reputation, credibility abroad. Issues permutations to the counterplan. NSC includes Article 3 judges, so it resolves their net benefits. McCarthy and 9 weaknesses in the convinced system really by federal judges. The NSC trials would add judges. Legislation will illuminate that their function is to preside, not take any action to expand or restructure delays the security issues, kill the counterplan, but the plan solves and their funding mechanism does not. Gora and 9 jury trials would take a substantial period of time following a trial period of terrorism trials falling the hill, and how info was used clearly affects national security. The logistical nightmare of a sheer number of trials is not internalized. We are talking about thousands of trials, not just one jury trials. Our processes are not going to crisis trials, but quite the opposite. Traditional courts will be less effective in preserving rights of thousands and not establishing an alternative paradigm will ensure continued not traditional courts will either compromise security or violate rights. DTC bridges that gap. Counterpoint weakens war fighting, and juries and judges are not adequate. The NSC is best. Solasi and there are some who advocate current civilian court system to try suspect the civilian court system is not appropriate. There are a number of problems. Applications of Fourth and Fifth Amendments are prime examples why this is unworkable. Combat officers are not police as unusual type soldiers to issue Miranda warnings on the battlefield. Consider the jury issues in Article 3 courts. A jury of your peers would be impossible. It appears ill-advised to use Article 3 judges to make determinations on niche law. Not all U.S. District Court judges have experience required with all the downsides. Some wonder if there's any way to control it. If there's any way forward. A national security court is that. It's those who decide the actual trial of these suspects closing of Guantanamo, the protection of state secrets, and the most efficient use of resources will still uphold rule of law. Will can take comfort in knowing that there's an effective alternative available. The counterplan links to politics or the plan doesn't. It also links to the race argument. Still changes the rule of law practices by applying it to terrorists. Also, all of the 1AC internal link cards are comparative, but as well as the Kimmery evidence as well as other things below.
No, we can do that.
Well, we probably need to. We'll
Okay.
read this terrorism thing. We can read the internal.
I'll read the internal link. Due process, their counterpoint collapses, intelligence gathering sources dry up, delivery, until plain streets, classified information open court, even a small disclosure or disclosure of some, and they will appear intelligence gathering, no causes global litigation would undermine, ongoing corporate operation or state secret claims, not claim, a corporate intelligence for disclosure or state secret showing affects their intelligence sources impact, initiatives, and the hard counterterrorism policy that causes extinction to 270, exhibition technology, and Duke exposed to KP, which is urban casualty, 1 million economic consequences, localized Duke casualty, severe international economic consequences would strike, their attack could generate casualty compared to full scale casualty, chances, nuclear conflict, colonies, smoke, could lead to global climate perturbation. Now the DA zero uniqueness without an alternative. They didn't read one because of conditionality. Nice try. Reuse specialized courts. Now with FISA, which terminally denies their impact. That is a rubber stamping mechanism that exists. That's so only a hope the app is better for the periphery because it creates multilateralism that can possibly prevent that violence. The national security uses Neville. The AUMF exists. FISA exists, etc. Which takes up the impact. Germany solves it better. Barnett and love the evil of Washington. This is the only other national responsible middle class world that's seen numerous world. Certain heads became the world. They're going to love the least racial civil part. America showed up and international trade order now for more than half the last historical secrets on that. America made the world farmer, placement, globalization, partner, may become number one enemy, it's not rejection movement. We have the force to actually manage global but that can be cost and dump serving money, convince ourselves that loss of Germany was a result of basically to grab globalization and expansion, not the greatest expansion of global team, but also the greatest consolidation of global peace, and the status quo is structurally improving, which is booster impact dash 2, 4. The world is getting better. Let's look like the data. Motion measurable metrics are necessary for me for equivalence having other happy died for HO away from mortality rate is much. The evidence shows that we're really good at solving challenges in the world, right? And their impact is literally just ethics in the 1NC. We get new 1AR answers when they clarify what the hell that means and they compare it to the affirmative. Politics. Congress has already passed detention restrictions to pound the DA. Alexander 13 Congress has not changed required on Canada to be held in military custody, making it difficult to prosecute them in federal court DC. Issued a series of a decade having government executive restrictions their sole executive power to end. Congress is already in the power to countermand the executive decision in order to maintain law-free policy. The DA will pass no compromise court in. 9-15 Obama Republicans are Stanley Obama proposed more tax revenue with closing loopholes for rich. Republicans won't take the right to debt ceiling. Republicans will only increase the debt ceiling. Obama plays healthcare condition. Obama is directed to decide non-judging contingency intentional evidence against the to do the plan pass debt ceiling won't pass Obamacare. Debt proposed 9-14 they were highlighted or threatening shut down the government retired to justify defunding Obamacare very unlikely to send. No, this is a separate measure would be ignored in the Senate to GOP squishing on Obamacare Republicans will support and increase the debt limit only if Obama can agree to delay his health program. If means the plan passes instantaneously doesn't cost capital, PCs low and fails for physical fights. Sergeant and I feel dominant factor shaping how they will play out. Bishop more Republicans will be Obama's percent of serious finishes capital. Standing in the week coming fights battle. The government different Republicans towards other terms of Obama saying the Republicans if any lower utterly relevant to Washington no to European maybe visual Obama will push the plan. New York Times and the president never advised the plan to Congress shut down the president or never going to make that mistake again. As Obama states the legislative backsliding arms to and holding volunteer to fight capital of Obama. Love them. Then healthcare had to go first. The plan is bipartisan to build and 12 Democrats will consider asking new bills demanding definition by person. Coalition support the amendment would amend to ensure that the cable lapse on military facility court steps are as doing these restore due process and testing. No, scratch that card. That's incorrect. Syria will cost Obama PC and wreck the agenda even with vote con 9/11 Obama. A temporary state of leaving Syria belonged to political policy that he will not emerge case there. Already been held much correctly. All resolutions protect federal Democratic agreements. Russia will be viewed as a two Obama priority on hold immigration and the debt ceiling on the back burner of the president as a weak hand by burning his political capital on Syria. There's no econ impact of this DA. Tanner and 11 Obama is warning of Armageddon in 1985. Congress raised 3 months after the debt limit reached in 1995, 4.5 months, and in 2003 months. None of these cases to the world and Mexico relations are vital to U.S. economic growth. Shifter and 12 their economic relations. U.S. Latin American regime robust sides every country would benefit with influence marks the U.S. and fixing the final African Latin rise economies being crucial to U.S. economic future. New opportunities, obviously, relations between future part atmospheric relations require urgent attention.
What was the last card you read?
Mexico key.
The two cards you read on the counterplay and the one in the dock are on this flash drive.
Okay.
Called new CT cards.
What's
CT?
the
My counter.
What's the DTC?
Domestic territory.
So that's what you will defend a domestic.
It's the way Welsh characterizes the National Security Court, but he says that there are requirements that Congress would institute that are defended in that Welsh solvency card, which you all apparently didn't read.
The 1AC Welsh?
Yeah, it's exactly what we said in the cross-ex. Things that your evidence does not assume. Things like, this is why we're not vague. Article 3 judges. There still is some state secret requirements, but evidence is no longer just hearsay, etc., etc. You did not take any of these arguments into account of the case or the CP.
Next question. Your CAA evidence, the term restriction is not defined by legislature for the purposes of DUI statutes. Why are DUI statutes relevant to the topic?
Because you have no evidence relevant to war powers, or this evidence at least makes a distinction between oversight and prohibition and says that as long as you create a new hoop, it's sufficient.
An important thing is that definition, that is the court defining what it thinks restrictions means. It's just in the context of DUI statutes, but that is how U.S. law defines restriction. They're applying a pre-existing legal definition.
So the threshold that you are establishing right now is that we read evidence in the context of war powers that says restrictions prohibition. That's the gold standard.
Well, we're not going to say gold standard because we're just going to say this is a court definition of the 1AR when you make that argument, and court definitions are better. Because if you just read a random card contextually about war powers, we'll say court definitions are better. But we also think that it would be great if you had a court definition that had an intent defined in the context of war powers. Maybe you could win the debate then.
Okay, cool.
Possibly.
All right, so your uniqueness evidence, you have a tag that won't compromise. Where do you think this makes a claim that it will not pass? So I see that you have parts highlighted about a stalemate. Where do you think it makes a definitive claim about
It just says, yeah, you're correct that the two key words are just stalemate and impasse, but the logic of the card says that Obama won't allow health care to be rejected. Republicans only want Obamacare to be defunded. There's no sense of a compromise there, which means that the debt ceiling cannot happen.
Okay, an underlying portion of this evidence, Boehner said we have a spending problem that must be addressed. Why does that mean that he will stand up to Obama?
Which evidence?
Same evidence.
Oh, yeah. Boehner says that, but our card above says Republicans in general, like the Tea Party in the House, etc., refuse to do that unless Obamacare is defunded.
I'm not sure if this is part of the same coalition. How many people are on board for blocking with Obamacare?
The majority of Republicans. I don't know an exact number, but our cards say it's sufficient to mean that that ceiling probably wouldn't pass, or that the impasse is sufficient.
Which piece of evidence do you think says that it goes beyond the scope of just the Tea Party that wants that?
Well, you're correct. The cards don't say anything about the scope, but they're broad about the Republicans, which I think is sufficient for us to make that argument. In the 1AR, we can make that more specific or less specific, but our card just says Republicans are blocking it broadly. You're right that it says Boehner says that we have to do something. That's rhetoric to appease the American people and for these news writers. RF says broadly, ideology means Republicans won't compromise on this. It's an a priori issue before they can do the debt ceiling, and they won't care if the government shuts down.
Counter-interpretation on quota.
Dispo.
Oh. I'll get that thing.
What? You get that picture? You got one?
Yeah.
Yeah.
Okay, speeches.
I know, I've forgotten English at least twice during this.
Yeah, I'm just like, I keep going to my semifinals folder, which I'm like, this is not this one. Hey, Birzer, can you set up this one? Alright, I just something out. I've been chugging coffee. Can I use the bathroom? I promise I'll sing the alphabet and not think about it too easy. Right.
I think it might be conditionality than like her overview, but I just have it all in the pit. All right, good.
Kelly, we clearly meet this violation. We prohibit the use of military commission TEPCO. There are Langdale evidences that says the post plan there would be definite detentions from the comments of a Google section. The rubber stamping evidences from is a question of solvency, which means they blur the line that causes our intervention, which internally turns all their arguments by reasonability is bad. The only violation they can possibly win is in the area of we counter that means it means scope. This solves all their net ground arguments because the affirmative must defend a ban on executive action, which gives them all the ground based on difference. He is extended but solved, and it also solves the plural of counter. There's no one advocates bad counter restriction means limit or condition on action. Ace one after there's only 8 Fs under their interpretation. There's no evidence that says, and there's no authority, there's no evidence for the court to ask most of those areas, which means there is actually only 4. There's none of those Fs have answered the executive counterclaim because there's no process-based advantages because they get out of the executive to ban himself from doing it. These one cause workspace. There is absolutely no literature on anyone that says we should simply ban Jones. The question of process, which is why the topic is about how authority is split rather than more general. TC1 topic education is impacted in and of itself. This is unique to this year. In a slightly unfair debate with better content is better than a fair debate that is a shitty overall reasonability is good as good enough. The negative had a fantastic strategy in this debate. Potential we should not be, but you should encourage theory that causes subset that encourages substance crowd and the theory prolif, which turns all of their arguments on the legitimacy advantage. We said that the failed states interlink was separate from majority, which means that if we went over some as modeling solvency up to the counterplan is unable to solve it, hegemony is unable to solve that. In fact, our evidence, other counterplan evidence is compared says the Sulami is fantastic, says the counterplan solves the perception of U.S. legitimacy, even though it's on Article 3 court. Our evidence from someone in the Coast Guard is a professor at Harvard. You should refer this evidence to all their evidence from Colson, who's at human rights first. What is that? And their Fisher evidence is an angry diplomat who's yelling at the United States that's irrelevant. our people countries know that we are at war, which means that if we don't use a Article 3 court that's legitimate, they're just a little bit angry about Guantanamo because it took it a step too far and started torturing people. But they understand that it is the war on terror, not the crime on terror. Now, the counterclaim conditionality will concede their interpretation of the conditionality is fine, but they should not be able to get contradiction, which turns their logic argument into truancy because Obama does not stand up and propose contradictory options. We were going to DDEV, we were going to strike DDEV this DA in the choice, but then the counterclaim was on an benefit, which means any of that offense would have been garnered by the affirmative negative simply going for the counterclaim. This kills the choice strategic choices. The data is already harder for the affirmative to and check too little, too late permutation, don't check. They are test combination on advocacy. Donahue evidence that executive procedures are bad because they don't have a jury, not the jury. Not that a lack of jury is bad in and of itself. The expertise argument is laughable. They cause amateur hour means people don't have security tools, cause massive leaks. The jury argument also doesn't make sense because there's no such thing as a jury for your peers for terrorists, which means that the counterclaim would actually result in Americans convicting every single terrorist that are tried in the court. However, it still links toward leaks DA because that is based on the perception of the leaks getting out, but it means that none of the terrorists would be released because Americans have a bias against terrorists, which means that the counterclaim would not be perceived as legitimate, which internally turns their argument independently delayed up. So the counterclaim will of course that doesn't assume the magnitude of the number of trials will be coming in, even if it's only 160 people. They say they have to set up a new security system, new prisons, etc. Or if they don't do any of this, they obviously link to the leaks DA because they would set up a shitty system, extend the war. They have conceded the internal link that intel is key to counterterror. All we have to win is a risk of a link argument and a risk of an impact argument, and we obviously have to win this debate because legitimacy is a linear impact, and you can't draw a threshold whether or not the affirmative solves legitimacy enough versus vis-a-vis the counterclaim. But you can say that intelligence operations were conceded and necessary to solve terrorism. So any risk that is bad, then this terrible civilian courts fail. I see the ask option Kimberly 9 U.S. courts not ordered to deal with the youth out of a second procedural property award itself as a hybrid based on Article 3, thank God, and military commission, this is the MS contract and the creative development law in terms of legal solution ambiguities, prevalent in our current system, look up the dedicated sort of that federal triangle judges working next pro prosecutor, high level security claims, when combined their counsel prosecuting terrorism cases system, the Constitution, and see his law review, Article 3 courts bad, flat, X7, Article 3 courts partly suited to handle security issues, unduly burden the military threat detainees, D, these perception of holding them and prevent them from returning the battlefield, Article 3 courts fail, McCarthy not handling detainees, is not security managed judicial function, adheres counterintuitive, undesirable, Article 3 courts, only under Article inappropriate, such a versatile presumption, antithetical in everyday practice of judging, and also now the terrorism DA, the war evidence indicates that the due process to terrorists in Article 3 courts discloses key intelligence. The key internal link here is that they would have to disclose the names of informants. That means all of our intelligence on the ground dries up because people would not want to be backlash by the terrorists because they would now know that they're an informant, which means the terrorists would go after them. Our evidence indicates that intelligence, the heart of counterterrorism policy, link is perception-based McCarthy 9 requirements. It ensured by deterring cooperation with allies, U.S. Civilian foreign cooperation with services in the areas with the threats American intrusion known as evidence violently keep the popular political intelligence system related to share information. Have members lead their information reveal out of discovered laws, U.S. criminal proceedings. Security measures don't solve answer C. McCarthy does a non-government intelligence release trying to judicial warming information in the theoretical subject and trade C. People are relatively unconcerned that violent order rituals acts made a very civil manner. Terrorists what they learned what they do are one of the officers of security second circuit court by writing a letter listing 200 names of who might be conspirators. The letter found the way to belong from Orchestra Ali Muhammad convicted in the Obama case using the criminal justice system causes more terrorism. McCarthy does not prosecute convicted more terrorism. This justice something high capable of counting the prosecution justice system increases that ethnic Campbell has often links towards recruiting trials and the criminal justice system enabling cause more terrorism and prosecuting the criminal justice system arming national terrorists. The intelligence improves their ability to harm Americans, even if the counterclaim itself doesn't link it, causes spill over that does. McCarthy does not judicial oversight is a person converting all the global and trials when tailing matters permitted access to courts judicial and under due process will treat them as if they're ready and every bit of evidence and due pressure needs more time regardless of the current national security until Congress have to truly assure you with our array of judicially fashioned rights of proximity. These criminal defendants 1 and C evidence indicate the 1 and C 2 evidence indicates that the terrorism causes extinction high risk dwarfing 2012 attorney bombs resulted in panic of socioeconomic destabilization of cities of vulnerable terrorists and maybe to penetrate legal facilities no engineering problems terrorist abilities simple gun type device information available and what would mean to weapon grade you from the plutonium as possible terrorists bomb is comparable to Hiroshima their explosion can cause serious economic damage to the political consequences nuclear attack would make public sentiment advantage to enhance control even different liberties and attack would cause violent protests armed clashing terrorists many attacks may follow the clash of solidarity making world order become the threat of nuclear terrorism is real successful attack related radical transformation of the global order yes nuclear terrorism abroad 2013 modern technology right from people small groups will really have that report we have to worry about private parties might get access to weapons or even more destructive like armed by the nation data diesel cover man woman child use government able to protect those from the greatest threats the conclusion of the vision of the see the enormity of the problem the will to combat every reason to disbelieve American attack on the small scale line not of an triple either the counterclaim links or either the counterclaim links or can't solve any of the case combination to the counterclaim the reject the argument not we're not going to go over the new judges evidence is all from a group of people training those judges obviously biased yes terrorism the war 2013 technology law and the sale of troops that are organized for recruit front president faction that was showing the difficulty of punishing of the state no security decision lead players demand act on their proximity for state formation technology someone representing leave out particularly feasible towards a group drive through human race to extinction.
What's the piece of legitimacy equals inevitable evidence or legitimacy equals linear?
It's fact. I don't know. I just said that. Legitimacy is linear. They want to know what Emma was saying for that. Birzer.
Should be on this folder.
In the file folder. Should be a picture of it.
Can you explain to me the DTC, like why the plan is not what why the plan is not what our counterpoint cards are talking about?
We read a card in 2AC that
Yeah.
the congressional establishment is different than just judicial review of the National Security Court by itself. That DTC card says the congressional statute would be able to remedy the problems with the broader National Security Court recommendation.
Oh, I typed that.
Yeah. Oh, you're in there.
Well, kind of. You should.
Yeah.
Pursue it.
letters T and then the challenge debate. I had way too much caffeine. I'm just like shivering. Alright, are you ready? The one hour has made a very calculated decision to blow off the heat argument. Go for 50 seconds. You have a very strong violence between one exactly two exercises. You have to draw exactly to the one hour. The graph is any rule of our ace of what you can see to the precision interpretation that even our interpretation might be seen a little bit arbitrary from logical precision. Precision should outweigh in terms of limits and grounds. The precise pricing of the resolution determines that we decide to research regardless of how far that division is price definition create in current unprepared debate participation. The gold standard for processing all debates long-term benefits because 90% of the debate research process they do not have a reason why their interpretation or any of the definitions are most limiting, which I'll get to in a second. The second reason the absence of rule are not a sending defense for why the interpretation is self-standing for limits arguments, which is Hughes brand that Birzer goes on the one hour. The third, or the offense they have not gone for any type of offense besides the nebulous over limits argument. The Pig's argument is not in the 1AR. You should not allow it to be brought up, and I will answer it anyways. Also, the last thing are we're the only ones who are reading a restricted definition of interpretation, which is why you should default to this on the top of the line by line. Look, do not mean the top of the last one's creative restrictions that prohibit the president's war power authority in the entire topic area that's the Northland and UNF is posing to conditions that you should prefer this interpretation for a couple reasons. A, self-point precision. The Rubin evidence says it's a legal definition for the whole procedure. Second, the legal dictionaries with gold standard for debates about separation of power, especially in the context of war powers authority. Their restriction evidence is about a court case, yes, but it's citing the Merriam-Webster dictionary and then it's talking about why prohibiting the use of cars in some random area about speed limits, which is clearly either A, not a court definition because it's citing Webster dictionary versus this one is an encyclopedia set from the Supreme Court, which is how they interpret it. Second of all, is that their evidence is not even about authority or anything like that. It's simply about cars, which is that we're controlling precision determining. The second argument that we are much more precise, on is in the area. They have a card that says the area, which is the area of study, which is clearly not authority. We're the only ones defining in the context of authority. The second piece of evidence is the word in. Look, in every other context may be right, but in the context of the in debate, we will protect. The in means they're in the context of jurisdiction. This is a piece of words and phrase and evidence, and literally says, I will rewrite it really slowly. Providing that justices should have jurisdiction in, the word in should be construed to mean throughout. That is the most precise interpretation, is the only predictable interpretation. We're the only ones doing in the area, which is one restriction modifies, meaning we are controlling this evidence. Also, the argument. The third argument is why the Birzer was pretty restricted piece of evidence. The piece of, a piece of Heinz evidence and piece of Roddick evidence are indicating that restriction is considered to be anything else necessary and limited. There are two arguments I do not think I have an answer to in the 2-1AR, and I'm not going to spend a lot of time. First of all, is the long one in our rant. It goes about why all of their apps is necessary and limiting, because each of those topic areas have multiple countries that they can each target and multiple types of restrictions, and then all done by the all permutation of those times the actors, which means they're over like 80 apps or something. The second argument that I do not hear an argument to is the ground argument. Yes, topic education may be important, but topic education only useful if we get links to those type of core discern. You can see the two arguments. A, someone is that there's no uniqueness in their interpretation because they do not prohibit the authority of the entire area, which means that we do not get links to the types of authority necessary restrictions to that, because they can say, oh, Obama still has authority, for example, in other areas of definite attention. The second argument is that it means that we do not get impact from areas, which means that we do not get defined for the restrictions because they can be a bunch of nebulous area on the exact line by line. I'm sorry, that was really crazy. Alright. The counterpoint says that they say that we meet our repression of the entire area. We have read a bunch of specific internal legal evidence about why our definitions will happen. The piece of long evidence says access to a trial does not restrict the definition because the definition is not progressed on the access to trial. And Roddick evidence says the national security course are saying rubber stamp on executive power. We are the only ones who are reading what the counterpoint does because it's not having any type of interpretation. We're just uniqueness. Argument for why they not meet the only test of question competition here should be in the worldly affirmative. Does Obama still have the power to indefinitely detain people? The answer is yes, as long as they have access to a national security court trial, which means that they do not meet our interpretation. They are going to try to make this counter interpretation in the area. I've done it before. Why this is why the interpretation didn't happen. There are a couple defense arguments I think that they're going to go for, which were not in the one area. A point is the Pix argument. I will preempt it here. Look, try really hard. It wasn't there. Even if it was, they have conceded a record of reasons why it is not the losing argument. A point is that Pix were never, but broad talks mean they're dumb pigs like the should pick. That is worse for education, worse for the B point is that Pix would be beatable. There's tons of literature supporting total bans. They can say the planning is the key to interpreting perception, or that the president will exploit loopholes. Also, the Pix are just really debatable. You could just be known with your also student picking up some right there, their plain text, so it's not textually repetitive, which will solve for any type of arguments. The second argument, they're going to go for topic education. You get your app as an advantage area, which solves all the topic education. I've already controlled why the restrictions are the only way to get disattached to the key restrictions, restriction on authority. Even if it is true that we do not equal the most apps, he does not have a coherent reason why over-limiting is better than under-limiting. You should prefer the over-limits. First of all, particularly for limits in the abstract field, they are not predictable. Nobody will research as a topic, never will go for condition case by case. Takes out any benefits for other topic. Also, we do not over-limit because there are at least 4 apps, and I think there are actually because there are lots of solvency advocates. Why, for example, Obama should not have any preemptive authority over OCO and should be taken to the covert action statute. That is a court case from the Birzer article. The second piece of evidence is that there are plenty of courts who think indefinite should be legal because of the habeas corpus rights, or, for example, the ADF should be overturned, which would prohibit his type of authority to indefinite in the area of war power authority. These are all forms of topic education. Even if that's true, there are 2 arguments you can see. The ASO in depth over breadth. The debate should 4 years reading is giving thousands of articles and never get deployed in debate around means you should not have room to discuss the majority of the topic. The areas we do talk about lacking integral or in-depth discussion, which is the reason why you should prefer an over-limit topic on receipt. The only argument he's going to go for is a 1 or 10-second argument about why we're good enough, which is not true. There are only 2 ways we're good enough. The point is that they meet our interpretation or close to our interpretation, which they do not. We have interpretation of it. Second of all, is they have a reasonable counter-interpretation of the topic. They have no argument why their counter-interpretation solves our limits argument, which is a conceded limits argument. We have pretty good defense about why their interpretation is good. Also, you should default competing interpretation. A one is that reasonability is arbitrary, subjective. The difference is possible to quantify. They should emphasize 2 subcommittee claims encourages to best for education. Third argument is that judgment minimize the integrity of the activity. Oh shit, conditionality.
Wait, we don't mix burdens because
we
it's a
don't
question
mix.
of the definition of it.
We don't mix burdens. It's a question of restriction. On the conditionality. Look, topically, I always theory the sheet of the first, which means it's a bad position. I have to read the reconstitution position. Also, this contradiction argument is new in the law. You should draw very high threshold for constitutional winning charge to argue. You cannot draw a line back to the 2 ways. You do not vote. Also, cannot research edible because people can read arguments like heat and show the links to this. That's the key to negative flexibility. The argument is magnified because they bring independent to to draw the this one doesn't solve because we always first permutation. Also, reject the argument on TNT comes prior.
Yeah, there should be a header for that. It's at the very top.
Okay. All right.
The 1 hour is light on this argument because the argument does not make any sense in the context of the affirmative. All the new Turin arguments, especially on the things about the cars, which was not in the 1 hour, and conditionality should justify any new explanations, especially if it's derived from the 2AC or 1 hour. They have the burden to prove that the argument presents the best vision of the topic, not just for this debate, which proves that if we present a better vision overall, you should vote affirmative based on argument quality and the actual vision they set for the NDT and the season overall. Now, the first, we prefer at the top, their interpretation is not precise. Yes, they have some cards about the court interpretation, etc., but they string together laundry list of definitions, i.e., their in the area card is about the law of the sea treaty. Their court definition card is not about war powers authority. They string these together to try to prove a precision impact that does not actually exist, which link turns all of their offense because they are incentivized to do things like this to artificially limit out the affluent to explain more on reasonability. We meet debate.
Okay.
Wait a second.
This is the most important question in the 1AR, and it's the argument that she spends the least time on. Her partner was trying to prompt her for a reason because they do not have a definition of indefinite detention in the process of the 1AC and the 1NC. Miles said that indefinite detention is when there is a lack of a trial. The moment when he said, quote, the courts we set up determine innocence or guilt. That is the opposite of indefinite detention. Seriously, the 2NR answer makes negative sense. She says that Obama would have the authority to indefinitely detain people after they had gone to the NSC. After the NSC, a person is either found innocent, in which case they're let go, or guilty, in which case they go to jail. But that is no longer indefinite detention because there has been a ruling. They have also conceded that it bans their evidence doesn't come close to substantiating their argument. Ace in point is reject their first card. It's from the comment section on Google, which is a conceded argument. Some random dude just saying that Obama may be able to do it, not legal scholarship, and our evidence is better about why he would no longer be able to use military commissions, which is our argument we've been advancing throughout the debate, i.e. is a ban on the current authority to use military commissions. Their erratic evidence is a solvency question, which is the only card she accepts, whether the courts would be effective. Looking outside the plan text, Rex affirmative ground, because the negative can always find random cards in the line to the advantages or solvency and say that proves topicality and mixes burden in a traditional sense, which is the worst form of topicality debating because it makes it impossible for the affirmative to ever read any app that makes any sense. I'll answer her arguments here. First, their definition is not precise. Our restriction evidence is about a court ruling and their authority. All of the 2NR new analysis here justifies the stuff above. In the area definition is bad. That was explained above. It's just our interpretation is better. It should just be the scope of authority, which we clearly limit because the scope of authority would decrease since you can no longer use military commissions, and the new commission process would be more restrictive on what you could actually do in the context of war powers authority. Words and phrases card that she tries to go for. The only reason this says in means throughout. You should read this card very, very closely because the line says that in this specific situation, all complaints that this judge had to hear meant that they had to go throughout the complaint. Because it says all in that card is the only reason it says throughout, which is a framing issue because the plan text clearly does not say all and the resolution clearly does not say all, which takes out any possible reason they can win this argument. Robert Stabbing was answered above. I will do some and now counter interpretation is best. It's the best. Our interpretation just that it has to be a limit, or this has to be a limit on authority. Prevents any app. Our definition is pretty fantastic about drawing the distinction. Yes, it may cite cars, etc., but that is not relevant because it is a court definition that defends what the court would actually, what we should be debating about government policy. It says that these types of hoops do actually change the president's authority, which are the only is the only question that should be relevant on this debate. They try to make a glorified solvency claim to answer this, but it doesn't make any sense. Now our offense to their interpretation aft ground. Seriously, there are 8 afts, possibly only 4 under their interpretation because they literally have only the banned drones, banned detention, banned OCOs, and banned USAF afts. These are terrible because they make the executive CP solve all of them. A conceded 2NR argument. They do not say the words executive in the 2NR, which makes it impossible for you to vote negative. Every debate past this point, if you vote for them, will have the executive counterplan solve every act because they could literally prevent themselves from doing something, and procedural guidelines are the only way to have an argument to beat the executive counterplan, i.e. the 1AC, which has procedural justice requirements as necessary for legitimacy of democracy. If we don't have those, there's zero reason why the executive can't expand himself. This is a huge impact because 8 afts over the year get stale. Basically, the NDT impossible and discharges affirmation, and means that everyone is literally banned after. They're also their ground arguments make no sense. There is uniqueness because we prohibit the military commission process and make it a more open and democratic process, which clearly gives you links to things like the war on terrorism DA, which they could have read. Also, their interpretation eliminates these type of process debates that we had in this debate. Think about how awesome the debate was in this round until the 2 hour, which was terrible because they went for this T argument. It could have been awesome going for the counterpoint. Seriously, that is a process debate that does not happen under their interpretation because all apps are banned, and all they go for is the DA and the app or the executive counterpoint and the app can never possibly win that. Now, the limits argument, there are, yes, the topic areas do have restrictions, which means that their 80 apps literally just feeds into your cult of limits argument. Cult of limits is so stupid. They are fear-mongering about 80,000 apps. None of those apps have good solvency evidence. None of those apps can actually win against the politics DA, so no one will read them. They are indefensible, which proves that argument should be discarded as fear-mongering. They cannot, the ground arguments, they cannot say that, will impact turn. Oh yeah, they can impact turn these type of apps as well and say that any type of restriction causes a perception of inflexibility. We did that in the doubles against Cal. We're able to beat a limited OCO's app by saying that that perception is sufficient to trigger any flexibility DA gets linked to the core generics. Over limiting is bad. It means all the impact work was done above. There's no solvency advocates. We cannot ban all of it. Indefinite detention proves that we've changed the definition. Breadth is better than depth, since reasonability means you should default to interpretation that's good is good enough. Being interpretation is just stupid. It causes arbitrary decision making apps. Flexibility outweighs neg flex. They have generics, etc., which proves that they do not have a right to make the smallest possible apps.